Start. The petitioner, through instant petition under Article 226 of the Constitution of India, is seeking setting aside of order dated 2 September 2023, whereby respondent state on the basis of letter of Food Corporation of India has directed the agencies not to allot paddy during KMS 2023 to the petitioner. Stop. The petitioner is engaged in the business of processing of rice. Stop. The petitioner is dependent upon paddy supplied by respondent state. Stop. The government of India, with intent to improve quality of rice, introduced scheme of fortification of rice. Stop. As per said scheme, 1 kg fortified rice kernels, for short FRK, is mixed with 100 kg normal rice, that is CMR. Stop. The processor of paddy is not engaged in the manufacture of FRK. Stop. As per standard operating procedure circulated wide order dated 15/03/2022 of the Government of India, there are notified manufacturers of FRK, and rice miller can buy FRK only from a notified manufacturer. Stop. At the time to delivery of FRK, the manufacturer has to furnish test report certifying contents of the FRK. Stop. The rice miller is supposed to install specific machinery to blend FRK with CMR. Stop. The petitioner, as per SOP, has installed requisite machinery. Stop. The petitioner during 2022-23 received and all connected cases paddy from state agencies and converted into rice. Stop. The petitioner purchased FRK from notified manufacturers and blended with CMR. Stop. The petitioner supplied blended to FCI. Stop. It is relevant to notice that no sample was drawn at the time of movement of stock from factory premises of the petitioner to depot of FCI and FCI, while stock was lying in their premises, drew samples and got tested samples from notified laboratories. Stop. 3 samples were drawn and test reports of all the samples are disclosing different outcome results. Stop. Learned counsel for the petitioners, relying upon letter dated 23 August 2022 of FCI, submit that FCI has asked state government to continue allocation of paddy to concerned rice mills because millers may not be at fault for quality of FRK. Stop. The said letter relates to KMS 2022-23. However, it is relevant because it indicates that petitioners may or may not be responsible for failure of samples because FRK is not manufactured by the petitioners. Stop. The petitioners have purchased FRK from notified manufacturers, and there is no evidence disclosing that petitioners have diverted FRK received from notified manufacturers and purchased spurious FRK from third parties. Stop. The role of the petitioners is confined to blend into the ratio of 1 to 100. Thus, they cannot be held responsible for any defect or deficiency in FRK stop.